On our sister program, StoryCon earlier, NBI Director Jaime Santiago said the cases they have recommended against Vice President Sara Duterte could make her serve a minimum of 6 months up to a lifetime in jail, although both the crimes of grave threat and inciting to sedition are bailable. But the question is, will authorities be able to compel Sara Duterte to reveal who her alleged assassin is?
Pwede pong ma-compel siya na umattend, pero yung magbigay siya ng information tungkol dyan sa bagay na yan, katulad namin, ay hindi pa siya nagpipili.
Meanwhile, Duterte ally Sal Panelo had this to say, and I quote, "The director of the NBI should go back to law school. His agency's recommendation to file criminal charges of grave threats and inciting to sedition against VP Sara has no basis in fact and in law. It obviously is tainted with politics and still part of the demolition job on her by her political enemies to put her out of contention in the presidential race of 2028. Now, the former presidential spokesman also reiterated that there can be no crime of threat from the grave. Neither has VP Sara publicly and tumultuously incited the people to perform acts of sedition as defined by law, nor to go against the constituted authorities or to stop the enforcement of laws. Panelo also said instead of harassing the vice president and wasting taxpayers' money, the NBI should instead focus on stopping and filing charges against legitimate criminals.
Now the ball is squarely in the DOJ's court, and let's try to hash this out further. We have with us tonight Justice Undersecretary Jesse Andres, who joins us live via Zoom. Good evening, Yusek Andres. Thanks for joining us and welcome to the big story.
Yes, good evening, Regina, Sean, and Pauline. Good evening to everyone.
Right, let's get right to it. This is a pretty heavy case to talk about. You heard our reporting earlier. The DOJ has already said it will undergo evaluation and preliminary investigation based on the recommendation that the NBI has filed. What happens exactly from here on? What is the, in that process, what do you do?
Well, first, let's put everything into context. The Vice President, while she is facing impeachment charges presently, is still not immune from suit. So this criminal case is one instance where a possible violation of the law can still be enforced against the Vice President on matters of accountability. So the law enforcement agent in this particular case, the National Bureau of Investigation, has come up with its report, its investigation report, and has transmitted the same to the Department of Justice with certain recommendations on possible criminal charges that may be filed against the Vice President, namely grave threats and inciting to sedition. So the process would require an initial evaluation from the investigating prosecutors to determine whether the submission provided by the National Bureau of Investigation, the evidence thus far submitted and adduced before the DOJ, is already sufficient to file a case in court. Let me emphasize something. This is a very good test case because presently the Department of Justice is enforcing a new procedure under Department of Justice Circular number 20, where the threshold of evidence that is needed before a person can be charged in court is now higher. It is no longer probable cause, but prima facie evidence with reasonable certainty of conviction. And what does that mean? When you say prima facie evidence, it means that all the elements of the offense or crime charge is already present based on the evidence. And the prosecutor's evaluation should mean that there is reasonable certainty that once presented in court, this will lead to a conviction. So presently, the complaint of the NBI is with the Department of Justice, and we will thoroughly evaluate the evidence. And part of the process is to subpoena the Vice President to enable her to submit her counter affidavit to give her due process. The preliminary investigation is a process where due process is assured the respondent. And we are not harassing the Vice President by issuing the subpoena. It is just a measure to enable her to get a copy of the complaint together with all the evidence and to allow her a period of time to submit her version, her counter affidavit, or any of her defenses. So based on what she will submit as her counter affidavit and what the NBI has given to the DOJ, then we will make that evaluation whether this is something that is considered a strong case that warrants a filing of the charges in court. Or otherwise, if there is no sufficient evidence, then we will dismiss the case for lack of evidence.
Just to manage expectations here, Yusek Jesse, she is not required to attend, right? She just has to submit a counter affidavit, which can be done through her attorneys.
Yeah. What is important in the process of preliminary investigation is the opportunity to be heard. So under the Constitution, you have the right against self-incrimination. You cannot be forced to testify if you do not wish to testify, and you can choose not to testify. However, after having been given the opportunity to put up your defense, then the Department of Justice will have to make that evaluation. So if she will submit her counter affidavit, then it will be part of the evidence that will be considered by the investigating prosecutor, and we are constituting a panel. The National Prosecution Service has constituted a panel that will evaluate the record. It's not just one individual. So based on the evidence that she will provide under her counter affidavit, and also what the NBI has already adduced so far, we will make that evaluation. And let me point out another matter. Under the new department circular, the DOJ prosecutors are also tasked to collaborate and coordinate with the law enforcement agents to possibly do a case build-up. Meaning, if there are insufficient evidence that are available at present, nothing prevents the law enforcement agents from getting additional evidence and for the prosecutors to help them and guide them in doing this case build-up together. Because the main purpose or objective of this reform that we have institutionalized is to make sure that when we file cases, we have evidence at hand and not evidence that we will secure during the course of the trial. That is no longer the practice. You have to have the evidence in the hands of the prosecutors before we commence the filing of the case. So that is for the protection of the accused, and that is in consonance with the protection of human rights.
So the threshold of evidence is higher this time. We're not just talking about probable
Yes.
cause. We're talking prima facie, which means all of the elements of the charge have to be there. There's a video of her admitting to contracting an assassin to kill the president should she get killed herself fall under that, because we're talking about all of this is because of that online press con that she conducted, right? So it came from her directly.
You got
She
cut
said it
off,
herself.
Okay. Yeah.
Go ahead.
Well, we are not making that evaluation. I am not allowed to make that evaluation. It will be the panel of prosecutors who will have the chance to examine and evaluate all the evidence together with the counter affidavit. But part of the real evidence or object evidence that will be considered will be the video that is now preserved and submitted before the DOJ. What is important here is that the threshold of evidence is no longer probable cause. Before you can be charged and the law can be used as a weapon because there is such a minimal amount of evidence. But here, the prosecutors who will certify that there should be a case filed in court will incur certain administrative liabilities if there is no actual evidence at hand. So definitely, there will have to be evidence that is sufficient to prove all the elements of the offensive charge. It can be grave threats, it can be inciting to sedition, it can be both, or it can be other crimes that may eventually be proven in the course of the case build-up. So you can imagine that the onus, the burden is now on the law enforcement agents and the prosecutors to build up a case. Everything that the Department of Justice is doing moving forward in the prosecution of cases is what we call evidence-based prosecution.
Okay,
So everything will depend on the evidence. If it is sufficient, then we will definitely apply the full force of the law. We will ensure that all the evidence that is needed will be there and will be presented in court. And we will make sure that the rule of law is followed. And due process is also strictly observed.
Yusek, there's two charges here. We're talking inciting to sedition as well as grave threats. Is it possible that the panel of prosecutors or the NPS, the task force will or could eventually decide to drop one of these cases or one of these charges?
Yes.
Is that also in the works or possible?
Let me explain that. The duty of the prosecutor is not simply to get incriminating evidence. No. The duty of the prosecutor, together with the LEA, is to gather all evidence that is relevant, whether incriminating or exculpatory, meaning evidence that could possibly cause the dismissal of the case is also the object of the investigation. So under our new rules, the LEAs and the prosecutors are tasked to do both things: consider incriminating and exculpatory evidence or evidence that will show the innocence of the accused. So we will weigh everything, and definitely due process will be observed by giving the Vice President full opportunity to present her side by way of a counter affidavit or even with the presentation of witnesses that she may bring forth to establish her defense. So that's much we are assuring the public. And if the Vice President is saying that the work of the NBI is as expected, our response is, it is as expected because the law should be respected. It doesn't mean that if you are a high official or an ordinary individual, a different standard is being used. No, there is only one standard for the rule of law, and the due process is something that we will guarantee. And a fair evaluation and a just resolution will be forthcoming from the Department of Justice.
Well, Yusek, you did explain earlier already that the Vice President is not immune to suit, but the question is, if she is found guilty, can she be sentenced to jail term while still in office? And are we correct, as we reported earlier, these crimes are still bailable? And tama po ba na 6 months minimum ang tinitignan na jail term for these crimes?
Well, correct. First, she is not immune from suit. Second, the offenses are bailable. And even if she is convicted, it cannot amount to her removal from office. But a criminal penalty, a sentence, could be rendered by the trial court after the court is convinced that there is proof beyond reasonable doubt, and a penalty of imprisonment could possibly be issued by the court after trial. But that cannot amount to the removal of the Vice President, and that penalty, if it will be implemented, has to be after. Because the President and the Vice President, as impeachable officers, can only be removed through that process of impeachment, which is a totally different process from a criminal prosecution.
Understood, Yusek. But following this train of thought, right, because of the higher threshold of evidence, which is now prima facie evidence, it also follows that eventually the panel of prosecutors could decide to just drop the charges if they can't find sufficient evidence, prima facie evidence at that.
Let me share the long-term vision of the Department of Justice. The court congestion is caused by so many cases filed where there is just a minimal amount of evidence that satisfies probable cause. That has caused so much problem already. That's why courts are congested with weak cases. We have to stop that practice. Only in this present administration did we institutionalize this reform. Only when there is a strong case and where evidence is complete will we actually file the case. so that eventually even the judges will find that the DOJ is very serious whenever it files cases. It does not file cases with weak evidence or weak cases. So that is the manner by which we will address court congestion. Cases that are strong will be filed, and the serious cases will only be based on evidence. And if there is no evidence, as you are asking, there is no other option but to discontinue the prosecution and dismiss the case. So that is also a possibility if the evidence is insufficient. And that will come after preliminary investigation and all the parties are given their chance to present their side.
So the DOJ is going to begin the evaluation and preliminary investigation. But Yusek, if I recall correctly, shortly after her online press conference last year, in November last year, we also spoke to the DOJ, not yourself, but I think it was Asek Clavano, if I recall correctly. And at that time, the DOJ said that it was already looking into the case. Right. So whatever happened from that, and are you saying that you're starting from scratch now, or you've already got a case build up?
No, we are not starting from scratch. The National Bureau of Investigation is an attached agency of the Department of Justice. It was tasked to conduct the thorough investigation, and it is only now that they have completed their investigation, and it is only now that they are submitting these pieces of evidence that they have gathered. So it is not correct to say that we are not aware of the previous things that have been happening in the course of their investigation, but they have formally transmitted the result of their investigation, their findings, and it will now be given to a distinct panel of prosecutors for preliminary investigation. That is a different group that will make that evaluation and judgment.
So, kumbaga, one department to another.
Right. No, I understand that the NBI reports to the DOJ ultimately, but the timing of this all, to some people, is suspect because obviously this is coming 2 weeks after her impeachment. We are, at the start of the midterm elections campaign. So it could be seen as political, is my point, right?
No, absolutely. I will have to say there's nothing political about this particular process. We have to be very circumspect. We could not file a case earlier. We could not, just fast track the investigation. We have to give the law enforcement agent sufficient time to complete the investigation. And if there is no evidence, then we will not proceed with the filing of the case. But definitely, if the DOJ, in the course of preliminary investigation, will find that there is no sufficient evidence, we will do what is necessary to give justice. And that is possibly dismiss the case. But all in the spirit of fairness, equality, due process, and always based on evidence. So we let us see in these coming days after we give the panel a chance to make that evaluation. And after the Vice President submits, hopefully, her counter affidavit, because even if she did not submit her counter affidavit during the proceedings before the NBI, she can still presently submit a counter affidavit to explain her defense and the facts surrounding her utterances.
Oh, so last year when she was summoned to the NBI headquarters to explain her side, she never appeared nor submitted an affidavit. Okay.
No, but she will still have the chance. We will provide her the chance.
But can we talk timelines here, Yusek? I know this is kind of an unfair question because sometimes things move differently. But as to Regina's point, and as you were saying, this is not political and it's just plodding along as it would in a regular proceeding. Yeah. Can you give us an idea? So you said that the NBI had this amount of time and they've determined that, okay, they're done. And now they toss the ball to the DOJ and now it goes to the panel of prosecutors. How much time will they be given for their preliminary investigation and evaluation? Is there roughly like some guidelines?
As I said, we will try to do everything in a very regular manner, meaning we will try to meet the normal deadlines, even for this case. And normally it is 60 days to 90 days for a panel or investigating prosecutor to complete the preliminary investigation. But again, we will be very flexible if the respondents would want more time to present their side. We will accommodate that. But ideally, it has to be completed within 60 to 90 days. If there are complex issues, 90 days. But if the evidence is already sufficient and the legal matter is not complex, hopefully we will be able to complete it within, at the most, 90 days.
So it's really like right smack, that 60 to 90 days, that's right smack within the campaign period.
That's within our rules.
Yes, and it's
Is
also...
there, let me be blunt about it, is there external pressure on the DOJ to fast track or move this case along?
No, no. Definitely, our mandate is to deliver justice. We call it real justice in real time. Justice delayed is justice denied, but presently, we have no other matter in our agenda except to give due process and finish this after a fair evaluation of the evidence.
Okay, so when can we expect, the next move from, at least in this case, would it be the submission of the counter affidavit, which is still an open invitation and can be done anytime? And then after that, we wait 60 to 90 days for the...
Yes.
But, yeah, like you said...
Yes, the National Prosecution Service will issue that subpoena soon after making its initial evaluation. And as I said, within 60 to 90 days, we will provide the respondent a chance to submit the counter affidavit and the NBI to do further case build-up. And then within that period, we will resolve this. And I assure everyone that the evaluation of the evidence will be done in a fair and just manner.
What's interesting about this is the Vice President herself does not see what she said as a threat, right? And if I may quote her, her response last year was, "Common sense should be enough for us to understand and accept that a supposed conditional act of revenge does not constitute an active threat. This is plan without a flesh," is what she said last year when asked about the threats. Even just a few days ago when she was asked about threatening the president's life, she said that was not a threat. That's she threw it back to the reporter. So she doesn't see it that way. Help us understand what weight this has on the case.
Well, we respect her opinion. And if she will only reduce that statement into a part of her counter affidavit, then that can be considered by the investigation panel. That's a most welcome response coming from her. And that should form part of our records, the evidence that will be evaluated. So if that is her point of view, then it should be part of her official statement under oath through the counter affidavit that she can submit to the panel.
Yusek, will the DOJ also be investigating the alleged threat on the life of the Vice President?
We wanted to investigate that even last year. If you recall, part of the reason for the subpoena of the NBI is to investigate the threat against, the alleged threat against the life of the Vice President. And unfortunately, she did not want to present herself before the NBI, and she did not give any other details. So it's very unfortunate, but we cannot begin the investigation without any specific leads coming from the Vice President. And hopefully she can change her mind and she can provide us the information. And we will forthwith, immediately, do the investigation for her.
We now know what that word means, everybody.
Well, the legal definition is still being debated about that word forthwith. But just to be very clear, as far as the DOJ is concerned, there are no active threats on the Vice President's life at the moment, as far as you know?
No, none that we have noted with our intelligence community and none with the NBI.
Okay. We're going to have to leave that there. Thank you so much for your insights.
Thank you.
It helped enlighten us to this case. That was Justice Undersecretary Jesse Andres.